Tort law. Negligently inflicted psychiatric injury. The law adopts a restrictive approach in awarding damages for negligently inflicted psychiatric injury. In addition to the Caparo test for imposing a duty of care, the courts have laid down several obstacles which must be satisfied by claimants in order to establish liability for negligently inflicted psychiatric injury. Firstly, there must be an actual psychiatric injury. This was established in Behrens v. Bertram Mills Circus, where some elephants stampeded and frightened the dwarfs. They did not suffer psychiatric injury, so the claim failed. Emotions of grief or sorrow are not sufficient to amount to psychiatric injury. In Hinds v. Berry, Mrs. Hinds could recover for her psychiatric injury caused by witnessing the defendant's car crash into the dormobile, causing death of her husband and serious injury to her children. The court held that her mental condition was more than emotions of grief and sorrow. Feelings of fear, panic or terror are also emotions rather than an injury. In Hicks v. Chief Constable of South Yorkshire, the two sisters were unable to claim for the terror and panic experienced being in the crush at the Hillsborough disaster. Initially, psychiatric injury claims were limited to those who feared for their own safety. This was seen in DeLayu v. White when the pregnant barmaid feared for her own life when a horse and cart crashed into the pub. The law has since developed to allow more wide-ranging circumstances but is still quite restricted. The leading case is Alcock v. Chief Constable of South Yorkshire. This arose from the tragic events of the Hillsborough Football Stadium in Sheffield in the FA Cup semi-final match between Liverpool and Nottingham Forest in 1989. South Yorkshire Police had been responsible for crowd control at the football match. They had been negligent in directing an excessively large number of spectators to one end of the stadium. This resulted in the fatal crush in which 95 people were killed and over 400 were physically injured. This case set a distinction between primary and secondary victims. Primary victims are those who are involved, mediately or immediately as a participant, as per Lord Oliver in Alcock v. Chief Constable of South Yorkshire. This was later restricted to those in the zone of physical danger in the case of White v. Chief Constable of South Yorkshire. This was another claim arising out of the events at Hillsborough. An objective approach is taken in determining whether the claimant is in the zone of physical danger as established in McFarlane v. E.E. Caledonia. In this case, the claimant was on an accommodation vessel at the time of the Piper Alpha disaster in which 164 workers on an oil rig burnt to death. The claimant feared for their own life. However, the court held that objectively viewed, his life was not in danger as the accommodation vessel was 550 yards away. The case of Page v. Smith established that primary victims only need to demonstrate that physical harm was foreseeable. There is no requirement that psychiatric injury was foreseeable. Secondary victims are those who are not in the zone of physical danger, but passive witnesses of horrific events. Secondary victims must demonstrate the four Alcock criteria are present, in order to establish a duty of care. 1. A close tie of love and affection. 2. Witness the event with their own unaided senses. 3. Proximity to the event itself or its immediate aftermath. 4. The psychiatric injury must be a result of a shocking event. 1. Close tie of love and affection. This will be presumed in parent and child and between spouses, but must be proved in other relationships. In particular, the Court of Appeal stated siblings are not normally considered to have a close tie of love and affection, so would have to prove the closeness of the relationship in order to recover damages. 2. Witness the event with own unaided senses. Seeing the events on television was not sufficient, nor was hearing about it on the radio or from friends. 3. Proximity to the event itself or its immediate aftermath. In McLaughlin v. O'Brien, a mother saw her family suffering in hospital before they had been treated after a traffic accident, in which one of her sons died. The House of Lords allowed her to recover for her psychiatric injury as she witnessed the immediate aftermath. In Alcock, the relatives that had visited the makeshift mortuary to identify loved ones were held not to come within the immediate aftermath of the event as they did not see suffering. 4. The psychiatric injury must be caused by a shocking event. Lord Ackner in Alcock v. Chief Constable of South Yorkshire stated, "Shock, in the context of this cause of action, involves the sudden appreciation by sight or sound of a horrifying event, which violently agitates the mind. It has yet to include psychiatric illness caused by the accumulation over a period of time of more gradual assaults on the nervous system. This excludes those who suffer psychiatric injury as a result of the long-term process of providing care for a loved one who has suffered severe injuries due to the defendant's negligence. In Sion v. Hampstead Health Authority, the claim failed as the psychiatric injury was as a result of witnessing the son's deterioration over a 2-week period. A failure to diagnose a kidney bleed was not a shocking event in the sense espoused by Lord Ackner. An exception to this is in relation to work-related stress, where an employer is under a duty not to cause psychiatric injury to an employee. This applies only where the injury is foreseeable. See Barber v. Somerset County Council. The position with regards to rescuers. Lord Oliver in Alcock had originally classed rescuers such as seen in Chadwick v. British Railways Board as primary victims. This was for policy reasons, in that rescuers should be encouraged rather than deterred. However, this position was changed in White v. Chief Constable of South Yorkshire. Rescuers are now to be given no favourable treatment. The position relating to those who believe they are the cause of another's death. In Dooley v. Kamel Laird, the claimant was able to recover when his employer supplied an inadequate rope which gave out when the claimant was operating a crane carrying a heavy load. The load dropped to where the claimant knew people were working but he couldn't see. The court held he was entitled to recover damages for psychiatric injury as he believed his actions had caused death or serious injury. In fact, no one had been injured or killed. However, this position of the law does not appear to have survived. In Alcock, Lord Oliver had categorized such cases as involving primary victims. However, in Hunter v. British Coal it was held that even where the claimant thinks they are responsible for causing death, they must also be in the zone of physical danger to count as a primary victim. Other types of claims against the police. In Leach v. Gloucester Constabulary, the claimant volunteered to be an appropriate adult for her local police station. Her first assignment was for the serial killer Fred West. She was successful in her claim for psychiatric injury due to the police's failure to ensure she was adequately prepared for the task. In Swinney v. Chief Constable of Northumbria, the police were liable for the psychiatric injury suffered by the claimants. They had supplied information to the police which was stolen when left in an unlocked car. The claimants received death threats leading to their psychiatric injury. In summary, psychiatric injury claimants are generally divided into 2 categories. 1. Primary victims. 2. Secondary victims. Primary victims are those in the physical zone of danger and only need to establish that physical harm was foreseeable. For secondary victims, the 4 Alcock criteria must be satisfied. 1. A close tie of love and affection. 2. Witness with unaided senses. 3. Proximity to event or its immediate aftermath. And 4. Shocking event. There are some instances of psychiatric claims outside of this which are decided on a case-by-case basis. This video is part of a series of videos on tort law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.